First, what we're going to talk about is going to be involving this guy, Tyler Robinson, who's accused of shooting Charlie Kirk last year in Utah. And it's about hearsay evidence that's going to be allowed in the shooting case by his reported romantic partner and former roommate.
Yeah, there's good lawyering that's happening in this case. So there's a couple of things. Obviously, we'll start with the first thing. This is a preliminary hearing, not a trial. That is key to what I'll say next. Typically, hearsay evidence is not allowed into a trial unless you can prove a number of things. One of the ways you can get hearsay evidence from a person that can't come and speak is something called the unavailability of a witness. And so if this person lives in another state, if they are dead, if there are some other thing that's stopping them from coming and physically being in trial, the other side could say, hey, I want to use their written statement, their sworn statement, their video statement in court and allow that to be used as statements that can be brought into court to go to the truth of the matter. Well, why would that be a problem? Well, a couple of things. Something called the Constitution. We have, as defendants in cases, the right to confront witnesses against you. So if this was a full-fledged trial, you should be able to have an opportunity to cross-examine. You should have an opportunity to ask questions, to be able to put them in a place where you can, impeach their testimony, to check their credibility. There are a number of things that the Constitution allows you to do when you're in a trial that you need the witness to be there for. And if the witness isn't there, you now as a defendant is put at a disadvantage. That's what his team argued. The prosecutors argued and said, hey, Your Honor, they're arguing things that normally would be at trial. We're not at trial. We're at a preliminary hearing. We're asking more about, did we have probable cause and do we have probable cause to go forward? The judge agreed with prosecutors saying, look, this is what we're arguing here at defense. You guys are arguing more trial strategy. You're arguing more things will be a limitation to your ability at trial, but not here. So I will, for this limited purpose, allow this person to not have to come and testify at this preliminary hearing, and because you're not going to be having an opportunity to cross-examine them anyway. Now, if you could show that their lack of being here would now somehow make it be less probable cause and make sure that the standard for probable cause wasn't met, different argument, but the judge didn't think that was it.
Yeah, in a separate court filing here, it revealed that Lance Twiggs, the reported roommate here, he gave investigators a recording, a statement over oath after Robinson turned himself in, and he told investigators that Robinson sent him message allegedly admitting to killing Kirk.
Yep.
And then in exchange, he received limited immunity from this.
That's something that I would hit on next. You must be reading at my notes. In exchange for his cooperation, Twiggs received a limited immunity, right? And so if we're at trial, I'm asking that question. Or are you promised anything? Or are you giving anything? Or are you giving the immunity to be here today? Well, you're asking that on cross-exam because now you want the jury that's listening to those questions or listening to his statements and just heard what he said to be able to say, well, man, he's saying these things because he was offered a deal, because they intend on giving him something later. That would be at least my attempt as a defense attorney to limit his credibility in the eyes of the jury. But again, the judge is saying, well, we're not talking about credibility. There's no full confrontational rights issue. There's no hearsay restriction. Why? Because this is a preliminary hearing. So it's the timing of the request and it's what's happening there. The standard is different. We're not asking for you to determine reasonable doubt. We're asking you to determine probable cause. And that this probable cause hearing is just allowing us to go forward or not.
And then the other thing here, too, is that this has been a case that has a huge case, huge international scandal, tragedy about what happened in the assassination of Charlie Kirk.
Yep.
But you haven't heard a lot about the legal filings and proceedings as you normally would hear going forward with some case like this of this magnitude and profile.
Well, I mean, I think the judge is doing a good job of managing the case. There's a couple of things that are happening right now. You have the prosecutor, while is still also waiting for some prosecutorial misconduct type of things, and so there are sanctions that could be brought before with the prosecutor because of a statement that this prosecutor made on a Fox and Friends appearance. Goes on there talking about, different types of projectiles and things that could happen and ballistic evidence to media outlets. And so the judge was made aware of it by defense team, and defense now is saying, because of these statements, because of the things that this prosecutor said, we're now wanting the state to be limited to to not bring the death penalty with this case. The judge has delayed ruling on that decision. So I think part of that's why you haven't heard much, why you haven't, found out a lot about what's going on in the case, because once that that statement was made by the prosecutor and the judge was made aware of it, now everyone's kind of hesitant to making a statement because no one wants to be held in contempt of court, to have sanctions held against them, to have their case limited in any capacity by the statements that they make outside of the courtroom. That's that prosecutorial misconduct that you don't want to have happen. That's why prosecutors are normally like generalizing the case. They're not talking about the specific facts of their case. Why? Because you don't want to taint the potential jurors in the case. You don't want to make sure that this person again is still innocent until proven guilty. There's a number of things that are at play there, and so this I think the speculation as to why the prosecutor is saying less because you're waiting to see if the judge is going to bring down the hammer for the previous statements that you already made.
Yeah, it seems like there obviously is there a lot at stake here for Tyler Robinson, the person who's accused of shooting Charlie Kirk. Uh, there's also been the defense. How would you defend this going forward? Talk about prosecutorial misconduct, but the defense is also saying that they have been denied a lot of evidence that they've been trying to get.
Well, I mean, I would say that that would be things that you'd bring up twofold in the course of the trial. You would bring them up in any type of pretrial motions, and you'd want to ensure that in the pretrial motions, hey, we're asking for discovery. We've been limited to get it. We've been requested it, and we still haven't received it. I mean, at the first time you speak at trial, you're going to say, Your Honor, on the record, I want to make sure that I let it be known on the record that we still haven't received the documents that we're asking for. So then, if the individual is convicted, right, if Robinson is found guilty, now that on the appeal aspect, you're able to say, hey, I preserved my appeal request during the trial. I know that there were issues. The judge ruled against me and said, hey, we got to move forward anyway. I need to now have a new trial, or I need to be able to still have these things turned over. So, like I mentioned before, that's good lawyering. Ensuring that you are preserving the record for appellate purposes is extremely important, especially when you're talking about homicide cases, when now you have an ability to, win or lose, but most likely both sides will have some type of appeal. An appeal that comes out, if you haven't preserved the record, and do anything with it.
Will cameras be allowed in the courtroom and something
I
like
mean, the
this?
state court, so you would think that there wouldn't be anything stopping it. I mean, in the federal court, obviously, that cameras are barred. We are in a need to know. We want to see what's happening right now, right there in South Carolina. The courtroom was jam packed with case in the Murdoch case, right? These folks want to be able to see these things unfolding right in front of them, with seeing and witnessing the what is it called, the wheels of justice turn. Is fascinating, right? And so while I would assume that this is something that would be done, there's nothing preventing it.
Queen City News Plus. Just search Queen City News on your smart TV's app store.